Hi, so we're here today with Elise Groulx Diggs. She's a dual qualified French and US lawyer and mediator, and she works a lot in the human rights and environmental due diligence space, helping companies resolve disputes when they arise. And we're really happy to have her on today. So, Elise, thanks for joining us.
Thanks a lot, Patrick. Just to qualify, I'm not a US qualified lawyer. I'm a Canadian qualified lawyer. Of course, I'm a French qualified lawyer. I'm a legal consultant with the New York bar. So I'm not fully barred in the US. Even though I could qualify, I just haven't taken the time. I'm a dual citizen, Canada, US, but so I don't want people to think that I'm a US qualified lawyer, which I'm not.
Fair enough. Thanks for making the qualification. Well, you're certainly a lawyer in some kind to make sure that you're going to qualify the statement properly. Maybe
Also a foreign barrister in London.
why don't we talk a little bit about your background and the work you've been doing in this space before the UNGPs and the CSDDs and all of these other acronyms. You've been doing work in the human rights and environmental space, so I'd love to hear more about how your career trajectory has come about.
Thank you so much, Patrick. Thank you for giving me the opportunity to talk to California lawyers. I'm very happy about that. I started my career as a criminal defense lawyer. I was a public defender for many years. So I started like really by representing very indigent people who I am to this date and who I became. And from being a criminal lawyer, I got involved because I had a background both in political science and international public law. I got involved in the creation of the International Criminal Court in the 90s. I started going to the UN, participating in the negotiation that led to the Rome Statute in 1998. I created two NGOs, so I developed the NGO world, I developed the negotiations world of the UN, which was extremely instructive and very interesting and a very rich experience. I mean, I was working on policy and on drafting laws because the UN system for treaties is such that the states do not have all the expertise they need. They rely on NGOs. So the NGOs, we prepare papers, we submit it to a group of states who decide that it's going to be their issue and they support you and you participate in the drafting and you learn a different kind of negotiations, which we can come back on. And from that, I created the International Criminal Bar for the International Criminal Court, and I was given a platform to talk about what I saw as unintended consequences of the creation of the new international justice system. And one of my focus was on corporate liability in conflict-affected areas, which is very related to international criminal law, which is really the law of armed conflict. So I started giving talks. My first talk on that was in San Francisco in 2003 at the International Bar Association, and then I gave many more in the years after that. And I started looking at the different modes of participation in international criminal law and how corporations could be the subject of international criminal law. So I did a lot of work in that space, and I got involved in the drafting of the UNGPs. There were meetings at the UN. I was invited to participate. I was insistent that international criminal law should be part under Article 25 of the UNGPs of the body of law that needed to be taken into account. It made it into a footnote. So if you look at Article 25 of the UNGPs, you'll see that international criminal law is in a footnote. It's not good enough, in my opinion. But so that kind of search for liability is what part of what I retained from international criminal law negotiations is that the NGOs, they really wanted an end to impunity for both tyrants and dictators, but also for corporations and their role in fueling conflict. So this is how I got into it. What is fascinating about this field of work is that you'll have people who come from banking, finance, pure corporate law, very different background from my own, but we all meet in the same space, which is the space of business and human rights. And so, I mean, I don't know if that answers your question, but I mean,
That's really
we could
interesting,
talk about that.
and to be honest, there's a handful of different questions. Maybe just to go
Go
back,
ahead.
my
Go
understanding
ahead.
of the Rome Statute and the International Criminal Courts processes is that's mainly the jurisdiction for those is mainly state actors. Is that correct? Because it's based on the
No.
Geneva
No.
Conventions. Oh, so it's state
Well,
and non-state actors.
yeah, non-state actors too, of course. The Geneva Conventions are form part of the body of law of humanitarian law. I mean, the
Yeah,
crimes, the war crimes. This
yeah.
is totally extracted from the Geneva Convention. But you also have another body of law, which is crimes against humanity, and
Okay.
later on, the crime of genocide was also incorporated, and the crime of aggression, which is a new crime in the Rome Statute, and they reduced the number of ratification necessary to 15. And so you now have a crime of aggression. Of course, you have many, many hurdles to be able to go on a proper
Hmm.
pursuit of the crime of aggression. And as you know, the main obstacle is the Security Council. But there is a solid body of law and a lot of jurisprudence around that court and around the tribunals that form solid precedent and solid definitions of these different crimes and different modes of participation and different form of complicity. So it's a solid body of law. Let's put it that way.
Mhm. And so and a lot of your work in say the early aughts was thinking through whether companies could also be held liable for international criminal violations. So for instance, if a company is sponsoring a let's say a right-wing militia in a Latin American country, let's just say, would that and that right-wing militia was responsible for war crimes, could that company be liable? Or is that some of the thinking that you were doing?
That's exactly what I focused on. I was hired by a multinational back in 2008. My contract lasted for 2 years. I was a consultant to that corporation, studying for them international criminal law and the different possibilities of being involved in an investigation. As you know, the International Criminal Court starts by investigating a situation, and then I mean some of it becomes public. I mean everybody knows they're investigating XYZ, so they really wanted to avoid that at all costs. And when you're acting in a country like, not to name it, like Iran, for example, or Sudan, I mean you have to wonder if you have issues of liabilities in your investments. And as you gave an example, war crimes is touchy, because war crime, you need to have a nexus to a conflict. So there has to be a conflict recognized at the level of the United Nations to be able to have a nexus to a war crime. But crimes against humanity doesn't need that nexus. And there are negotiations, as we're talking today, ongoing in the US to have a statute on crimes against humanity, which doesn't exist yet. But many of the countries that have endorsed the Rome Statute and ratified and incorporated it into their national legal system had to adopt these kind of laws, because that's part of the law of treaties. It has to become part of your national body of law. So the US is not a member of the ICC. Um, Trump signed, not Trump, Clinton signed it with Israel on the 31st of December 2000. They signed the treaty, but then the first thing Bush did was unsign the treaty. And of course, Israel followed, and they also unsigned the treaty. But there was a desire to get involved. And the US has been extremely active and participating in all the negotiations and all the different events that have been happening. So you have a group of top experts in the US in that space.
That's really helpful. And over the course of your career, you found yourself working as a neutral, working as a mediator.
Oh,
And
that's more recent. That's more recent. I trained as a mediator in the early 2010. I became certified, and then I did more training in international mediation, and got qualified also in France for mediation, and was hired by a German NGO back in 2021 um, about a mediation in the textile industry in Myanmar, opposing workers from Myanmar just after the coup. The coup was February 1, 2021. I was hired in August 2021. And the other party was the Chinese employers. And there were the brands, the European brands and the international unions were involved in that negotiation and that mediation. It lasted for 6 months. It was unfortunately all online because of the pandemic, but it was an incredible experience, which enabled me to put all my qualifications to work in that instance. And just to give you an example, they were offered an incredibly small settlement possibility at the beginning, and we got like 100 times what they were offering. So it got resolved, and we got a resolution that I thought was acceptable for the workers. The workers were living in absolute misery. And that's about being neutral. I was supposed to be neutral between the Chinese employers and the Myanmar workers, but I was explaining to the Chinese my conception of the rule of law. And I said, usually, in mediation, you'll have two parties that are about equal. And here we have one party that has absolutely zero leverage, and you have all the leverage. So as the mediator, I have to rebalance the whole building to make sure that the party that has no leverage remains at the table and has a voice. And anyway, I took a long time to explain that to them, but they seem to come around. And what I had learned at the UN was to work the backstage, that you have parties in front of you, but you have actors that are so important to making a difference, and to get them involved at every possible stage of your mediation. And that's what I did. And that was from the human point of view, from a lawyer's mediator point of view, and from let's say a creative point of view, it was fabulous, because in that kind of mediation, you have to do a fact-finding mission. You have to be able to collect the facts and make sure that the parties agree with your reading of the facts. So you have to constantly come back to the parties to say, is that what you said? Do you agree with that statement of fact? And of course, it changes all the time. It takes a long time to get to an agreement, simple on facts. And as you move forward, then your capacity to examine and cross-examine can become handy. Even though you're not supposed to lead a cross-examination, you still can remind the people who are coming back on the facts that they sign a sworn statement, and why are they changing. So you can use some of the techniques of cross-examination that you develop as a court lawyer, and try to get them to come back to what they signed and agreed to sign. And then you have to, while remaining neutral, you have to not only propose solutions, the solutions have to come from them, but you have to kind of endorse the solutions that you think are reasonable, and making sure they think it comes from them, that it's their idea, and that you're willing to support their ideas to make sure the conflict gets resolved, and to show to them why it's important to resolve the conflict, what's the benefit for them, what's the pitfalls if they don't resolve the conflict. So in that same context, I did a training with CEDAR, and it was
Maybe
focused.
you could explain what CEDAR is?
Yeah, CEDAR is the Center for Effective Dispute Resolution. It's based in London, and it's a very, very solid training venue for mediators. And I mean, it's not formulaic. They really try to get you to be practical, but to think the process of mediation inside out. And one of the focus was on peace mission. And peace mission was so close to what I'd been doing at the UN that I thought I was in the UN context once again. And I at the end, they asked me why I wanted to do that training. And I said, because I want to be able to apply that to environmental issues, human rights and environmental issues. So that experience together with, I mean, the expertise I've been developing, I've been hired as an expert in the last 2 years by UNEP, United Nations Environmental Program, to do a report on greenwashing, which I can share with you and your readers. Um,
I'd be
it's
interested
just,
in that. What
yeah,
does
no,
the
I'll be
report
happy
say?
to share. I'll be happy to share. But the idea is really to when you get into the field of international law and international affairs, you have to put your national knowledge basically on the back burner as you're developing your own expertise. And then your expertise comes back to play in favor of your work. But for a while, you have to put it on the back burner and come to that new forum completely basically empty of your prejudice or preconceptions or technical expertise, because they're not the same in other jurisdiction. And if you stick to your technique or your technicity or your pointed expertise, then it becomes impossible to exchange with other colleagues. And I find the beauty of comparative law is not to see the differences between the system, but to see basically how all these systems are human systems and they have a lot in common. It's to look for the common thread. And then you can start identifying the differences and identifying your own proper
Mm.
expertise and your own proper sphere of, well, excellence or specialty. So it's
Yeah,
by
particularly
having,
in the context of mediation or arbitration or dispute resolution in the international sense, you're using law as your basis for your common language, the way you're speaking, and it forms the framework of the rules that you're arguing about. But at the same time, you're still dealing with people. And so
yeah,
you mentioned
yeah,
earlier that people in general, they want to take ownership over the solution. So even if you're a Chinese person, you're a Burmese person, you're a Latin American person, or a European person, you generally have that same thought process where you want to have ownership over the solution and you want somebody else to validate that ownership or that solution. I wanted to
absolutely.
ask
But
a little bit
uh,
about the
just add
CMC. Yeah,
one thing about that for a second.
sure.
People also want, when they come to a forum like that, they've had a long process of frustration and conflict that's been flaring and degenerating for a long time. And people want their day in court. They want to be heard.
Mm,
So it's kind of the art of the mediator to create a climate of confidence, of trust, where these people feel they can really express themselves and that whatever, however unreasonable point of view they might put forward, you're going to listen to them. You
hmm
will be very focused on letting them have that famous day in court.
hmm Yeah, and if you're thinking about it in terms of what type of what the type of remedies that stakeholders often want, sometimes it's less a function, a less a question of, financial damages being paid to them, but more just feeling validated and feeling like their voice is heard in the appropriate forum.
It's a mixture. I mean, in some cases, the money is certainly going to help people feel validated, but often it can. I did a big mediation a few years before that involving a big hotel and slave labor in the Middle East. And the workers, they wanted an apology from
Hmm
the owners.
Yeah.
And that made a huge difference to them to have an apology. So it was a recognition that the suffering had not been just in their head. So I would say that mediation is really the marriage between psychology and law. And I mean, when you've practiced a long time, it's very stimulating to be able to use all these techniques and this expertise that you've developed and bring it to fruition for a good purpose, to have an impact and get people to resolve the conflict. So take climate. I mean, a lot of the issues in climate is about land ownership. I mean, people have to be displaced. Depending on how they're displaced, it can amount to a crime against humanity. I mean, I won't talk about war crimes again, because war crimes, you need to have the nexus of a recognized conflict, which is something particular. But all that to say that you need, oh yeah, climate. So you need to bring a large group of people around the table. You need to bring the affected community, but the community that lives around the affected community that might not be affected directly, but they might be affected indirectly. So I always tell my clients it's better to open a large forum, as you might clean it as you go. You might reduce the number of participants, but it's better to appear to be open and transparent so that you don't create a lot of suspicion around what you're trying to set up. And in the case of climate, I'm sure you can easily imagine how it's possible to create a climate of suspicion. So you were asking me about the CMC. It's the Conflict Management Committee. I'll send you the link to these rules. I was hired by the European Union in the fall of 2022, January 2023, to draft a framework for large mega infrastructure projects like mining, oil and gas, agribusiness, land, forest, and infrastructure like construction sites. You know, it can be a huge bridge, it can be a huge windmill field. I mean, anything that's big and that involves a lot of people. And they were asking me to create a set of rules and a framework that would find a way to anticipate the conflict, not only resolve the conflict, but see how it's possible to anticipate it and then prevent it as much as possible. And of course, then resolve it. So, and I hired two very commercial mediators to be in my drafting team, because I thought, my being a human rights lawyer, I needed to have commercial people to really see what is feasible or not feasible. And it was, I mean, they were really a call to reality. They were giving an air of reality to certain of my ideas because they knew the business world. But we ended up designing something that we're all very proud of, which is something that can be used in very many mega projects and could anticipate conflict. We presented it at the World Bank last September 2023, and the World Bank was very positive and supportive. And we created a large peer review group. And now we're trying to work with the American Bar Association to create new clauses in our framework to apply to supply chain, so that we could appoint a neutral as we build a supply chain to watch, manage, and see what's happening in the supply chain, and grab potential conflict as they come to life and try to solve them as soon as they come to life. So to prevent abuse on labor issues, like the number of hours that you're working, the number of hours that you're paid in comparison to what you really have worked, the working conditions, the conditions of the premises, the dangerosity of the working conditions, the days off that you're supposed to have or not have. Of course, all the issue of discrimination between men and women. So this is something kind of new that we're getting involved in with the support of the business law section of the American Bar Association. And I think this is very complementary to the first part of work that we've done. And I mean, it just like prevents conflict. I mean, it anticipates and prevents conflict. So we hope that investors will start looking at these products as something that guarantee the sustainability of their investment. And especially, as I said, in the context of climate change, where the cost of disasters are so high, and they're only going to get higher. So anticipating these conflicts can be very not rewarding, but certainly positive for investors.
Hmm. Yeah, no, so yeah, and I imagine that these large infrastructure projects, which have a substantial effect on potentially indigenous communities or whatever local community that might be cited where the infrastructure project is, or might have some downstream effects to the infrastructure project. You think about a mine, they might have environmental stakeholders downstream. I would imagine that having a appropriate system for resolving conflicts that's thought through well in advance is much more beneficial than just an ad hoc system. And I'd expect that over the last, it's usually the case that there's ad hoc systems to address these conflicts that arise. Maybe you could tell me a bit more about why the CMCs are better than just an ad hoc system.
Well, the ad hoc system, I'll take your question, that part first. The ad hoc system happen when basically trust is broken.
Mm,
The conflict has degenerated to such a degree that the company decides that it needs to do something.
yeah.
And I mean, it's to reconstruct the trust that's so hard. I mean, it takes years to build trust and it takes minutes to break it. And so these projects, these ad hoc mechanisms are not put in place in bad faith,
Mm.
but they are kind of counterproductive. In the CMC, what we propose is what we call a stakeholder engagement plan. So from the very beginning, at the beginning of the project, the parties and the stakeholders and the governments and the civil society and the representatives of the communities are invited to a roundtable where we discuss all the potential negative impact of the project. And then the committee, the conflict management committee, monitors the implementation of the project to make sure that what was uncovered in terms of potential risk is dealt with in a proper, punctual manner as they occur. And that helps to build the trust. Instead of, I mean, we've seen, for example, in Peru, project being paralyzed for years because of social conflict.
Mm.
And I could tell you now, and it's a very rich mining country, that about 50% of the projects are paralyzed by social conflict. So this is not a good solution for companies to wait until the conflict blows up in your face and to have to pick up the broken pieces and try to mend your puzzle back together. That's why we think that anticipating and having a very open process to build a consensus on the issues ahead of time is way superior to trying to repair.
Yeah, I was going to ask you a bit about the legitimacy of the different parties and whether and how you have to ensure that each all the parties have trust in each other. But I think your point is that if you wait until you're at the point where the parties have degenerated to the point where there's no trust, that's when you really can't resolve conflicts effectively. But if you have a process in place throughout so you can address small conflicts as they arise, I would expect that the process of addressing those small conflicts actually builds trust because it
Absolutely.
gives the parties an opportunity to show good faith.
Absolutely. Absolutely. And I strongly believe that building a system that would be more modest in the supply chain, but that would be functional up and down with a capacity to investigate cases as they come up and the ability to resolve them, to be given the power to resolve them, can lead to very fast resolution, much cheaper resolution, and also the capacity to prevent a complete degeneration of your supply chain. And then, I mean, unmasking the fact that you have slave labor in your supply chain, which could kill your reputation instantaneously. So this is all to build your image and to anticipate the problems and to show that you want to be transparent and you're really acting in good faith to respect rights holders, stakeholders, and especially the most vulnerable one. So that's the challenge, and to try, of course, if you anticipate the remedies that you're going to be offering are not going to be the same than if you repair after 5, 10, 15 years of damage.
Mm-hmm. Mm-hmm. Yeah, yeah. You're reducing the scope of the damages, so you're also reducing the scope that you have to repair.
Yeah.
Mm.
And I mean, by building that trust that I talk about, you make sure that people are motivated to continue with the project, that they're happy with the project, that they realize that the project brings something to their community and that they benefit from it. And and for example, Indigenous people have become very aware of all these issues, and now they're demanding to be part of wealth sharing, not just to be left in the state they were found in, but to really participate in the wealth that's being developed from their land or their resources. So that's a new current that's getting a lot of wind, a lot of strength that needs to be taken into account. And again, that kind of current, if you negotiate in good faith with these people from the get-go, is going to go more smoothly than if you try to crush their demands and just say no and no and no until everything just bursts. And because of climate change and because of the world we're in, we need these resources. They're essential to the transition. And that's part of what I call the just transition.
And I'm just curious on a practical level, how is it that the CMC is kind of incorporated into the project? Is it that for instance, the World Bank or whatever institution, the IFC that's financing the infrastructure project requires the company that it's providing finance to utilize a CMC, or is the company or the consortium perhaps that's undertaking the infrastructure project, do they voluntarily decide we are going to implement a CMC? Is it a mix of both? Or is there some other avenue where the CMCs arise?
Well, you're in the area of contracts. So, I mean, contracts, I mean, CMCs would be part of the contract. And so it means it has to come from the parties, but it can be not imposed, for example, by the World Bank, even though it could become a standard, a
Yep.
recognized standard that before you start a big project. And that's something we've been thinking about. One of my partner is participating in the negotiations, the UNCITRAL negotiations. This week it's in Vienna, and she's trying to get a recognition for the CMC in the UNCITRAL. UNCITRAL is the
Yeah.
treaty on bilateral investment treaties. And I mean, it's been shown to put people in a situation where they have to do things that's contrary to their own interest. Like there's a case in Africa where a country is trying to to be aligned with requirements for climate change, and because of a bilateral investment treaty, if they do that, they break the bilateral agreement, and then the company wants to sue them. It's kind of a non-starter and a nonsense at the same time. It doesn't make sense that you would prevent a country to not do what's good for them on account of a bilateral investment treaty that was negotiated with different factors in mind at the time. So, I mean, it requires that you rethink a lot of things, but standards would certainly be one. I mean, you could think about the equator principle mandating this kind of mechanism. I mean, we're thinking about all that. But I think until we've proven the value of what we do, until we've done, let's say, 10 projects, it's going to be hard to sell that
Is a
as a
requirement.
model.
Yeah.
So yeah, as a requirement.
Yeah.
So I mean, everybody thinks it's a great idea, but we need to apply it to projects, uh,
So that's the next step.
big and small and
Having
medium
a
all over the
series
globe.
of examples where you can show why it's effective. Because yes, logically this all makes sense. And now it's just showing it over the course of the next few years. So I usually kind of end these
Yeah,
conversations.
what we're doing right now, Patrick, is we're building a database of
Mm,
different cases where the CMC could apply. Because in the best of world, you should have a CMC at the very beginning of the project, but there are many projects where the conflict has been ongoing for 5, 10, 15 years. So we still can come in and try to resolve these conflicts.
mm. But I guess that defeats the purpose because part of the genius of the CMC is that it addresses conflicts before they arise, so you maintain trust, which allows conflicts to resolve much easier than when the parties' relationships devolve. Um, so
Well,
yeah,
that's in the best of world. But if we can prove that our methods, even though not applied at the beginning, still have a lot of merit and value in diffusing the conflict, applying different methods, and especially being neutral, because when the company sends its teams to resolve a conflict, people are not neutral, and the neutrality of the people intervening in the conflict is fundamental to build the trust.
yeah. Yeah, I would imagine so. If a company appoints a team of fixers to go in and try to address it, and they're being paid by the company, the other side of the equation, the stakeholders are effective, obviously feel like they're representing the company. Um,
Yeah, I mean it's especially in a conflict that's already flared up, ongoing, expanding. You can almost be sure that the stakeholders will not be willing to negotiate in good faith with the representative of the company because the enemy for them is the company.
So I usually kind of end these discussions with a question about where do you see the future of this space? And we talked a little bit about this, about applying these CMCs in more projects. We also talked about using the CMC in the context of a supply chain relationship, which is another ongoing commercial relationship. I wonder, are there any other kind of thoughts you have about where the future of kind of conflict resolution in the EHG space is?
Well, I'll take you on another space. I mean, you know, wars are usually very prone to get people to make progress in the way they think about issues. So I think about medicine, for example, where they developed the first medication against cancer, methotrexate, after the First World War. That's what they call the mustard gas that were used. And then they realized that these mustard gas had an effect of slowing the growth of white cells. And then they developed them in the fight against cancer. That was done 100 years ago, and it's still a fundamental tool in the fight against cancer in chemotherapy. So and the Red Cross was developed in the First World War to stop the worst suffering of the soldiers on the battleground, and that's where they developed these ground rules. So right now we're in the middle of two major wars, one in the Middle East, one in Eastern Europe. And I do believe, as you know, these two leaders are being wanted by the International Criminal Court. I'm not saying they're going to end up at the International Criminal Court, but traveling is going to be difficult for them for a while. But the civil society and the people coming out of these wars are going to want to see some accountability. If it's not happening at the level of the heads of states, the accountability is going to be looked at towards the companies that fuel the conflicts. And I can almost bet that you will have a revival or an expansion or new development in international criminal law on these issues of liability of corporate actors and fueling conflict. So that's a development I see happening, as I hope these wars will come to an end sooner rather than later. And that will be, I mean, from a strictly legal point of view, it's going to be an important development, but it also can lead to progress if we develop codes of conducts that are binding on actors that sell weapons and sell energy, to conflict, to parties in a conflict, it's gonna maybe limit conflict. I mean, I want to see it as a limit to conflict. And climate change is a challenge that we are only seeing the tip of right now. And if we can apply these methods to create a climate of communication and consensus building between people on issues that are going to be so huge to resolve, I think there's a lot of work to do for lawyers and conflict specialists in these two areas that we're plunged into right now. And we're like close to the wall. We don't see how it ends, but it will end like everything human always ends. And we'll have to come up with creative solution. And climate is going to be the challenge, I guess, of the next 100 years.
Well, that's a very fascinating look at the world and look at how the future is going to go. So thanks for sharing that with us, and thanks for joining me today and telling me a bit about the work you've been doing.
Thank you so much, Patrick. And good luck to you. And I'll be sending you links to some articles that could be of interest and to the rules that I've been talking about so that you can share with your public.
Great, thank you very much. Yeah, we'll put those in the show notes.
Thank you so much, Patrick. Talk to you soon. Good luck.